Partly allowed.
Deeply obliged.
Lordship, may I mention? Lordship, may I mention a second appeal for hearing, my lord?
When?
Or any date, your lord. Deeply.
Well, at item 25, my lord, I have been newly.
Viola. You mentioned the matter before the state report. Court number 8.
Number 8. Well, item 25
Yes.
of today's list, my lord.
Yeah.
I've been newly engaged as a standing counsel for the ASTC, my lord, and I don't have the proper records. Can it be listed
Number 20?
5? It is in main list. My friend from the other side is also.
I'm 40 response.
Well, can it be listed after 6 weeks? I have to reconstruct the records.
6 weeks will be a little bit long. 4 weeks, your lordship, that date
4
may
weeks.
kindly be fixed.
Why reconstruction? Reconstruction of your file?
My file. My file.
Oh, your file. Okay. Mr. Somua, current counsel for the respondent. Oh,
You
sorry.
know, my lord. Appellant.
Appellant. Okay. Appellant with concept the other side. Respo fixing the matter after 4 weeks.
Yes, my lord.
4 weeks. So as to enable him to go to construct the file as he has recently been engaged with. There is according necessarily the after 4 weeks.
So I'm praying for a date to be fixed. A date to be fixed, your lordship.
Date.
My lord. I'm obliged.
May it pleases your lordship. Lordship, with the consent of the other side, I beg to mention item number 16 of the daily list. 1-6. It's been listed for admission hearing. For admission hearing. 16. 1-6. 1-6.
Okay. So the prayer being made by Mr.
AI Ahmed.
Yeah. For the appellant. You inform
For the appellant. We will inform the other side. After 2 weeks.
After.
Deeply obliged. May I beg to mention item number 13, my lord.
30.
13, my lord. 1-3, my lord. Do you have some difficulty, my lord?
30.
Is 1-3, my lord.
1-3.
1-3, my lord. Only for the day, my lord. I'm paying examiner for the day.
Okay. Mr. A.K. Azad, current counsel for the appellant. On the prayer being made by Mr. A.K. Azad, current counsel for the appellant. Matter is adjourned for the day.
Obliged.
May it be pleased, your lordship. Lordship, I beg to mention item number 2, lordship. Matter may be adjourned for the day, lord.
Item number 2.
2, lord.
Okay. On the prayer being made by Ms.
S.A. Khalifa.
S.A. Khalifa, current counsel, appearing on behalf of Mr.
M.A. Sheikh, lord.
M.S.A. current counsel for the petitioner. The matter is just adjourned
For
for the day.
For the day.
May it please your lordship.
Yes.
This is a second bail application, lordship, earlier rejected by your lordship. Rejection order starts from page 25, lordship. Relevant part, page 27, your lordship.
What is the ground?
Lordship, kindly peruse page 27, para 8, lordship. Para 8, lordship. Since no witnesses have examined so far, lordship, this court is of the view that without examination of the crucial witnesses such as victim and the informant, lordship. Now already, lordship, 7 witnesses have been examined, including the victim, lordship. At this stage, notice may go, lordship, postco matter.
For the appeal. That's for application. Was it saying that arising out of NPK PS code number 1 under section 376 824 of the POCSO Act. Pending before the court of learned action of the special the POCSO in the Board of Learned Council the submitted the second bill court and the first one being BNFRT 4 but by court high order dated 1 and the Board of further that the first bail application was rejected by this court on account of non-examination of the crucial witness and now 5 witnesses,
Seven, Lords.
7 witnesses have already been summoned to the
Lords.
and therefore the accused approach this court again for granting the sub court that is not the comment of part 2
Lords.
by registered to the office of the PP, office of the Assam. And also call for the scanned copy of the record, the court court will of fixing the matter on
18.
have to obtain a report with respect of the
Regarding service.
Oblige, your Lordship.
your name is not there.
Lordship, I am appearing on behalf of Mr. A.K. Gupta. He is unwell, Lord. Oblige, your Lordship.
May please, Lordship, this matter may be fixed for hearing, my lord.
Last fixed in the September last year, my lord.
A date may be fixed,
Date
my
may
lord.
be, short date may be fixed, my lord, for hearing, my lord. Achha.
Oblige me.
In this case, what?
Service is complete and LC has been received. Lord.
My lord, file IA for allowing me to withdraw the 50% of the deposited amount. I filed long back, my lord. I-697, my lord. There,
We have filed objection, Lord.
uh,
Amount is deposited.
yes, my lord. Long back, my lord. In deposit.
I have filed objection, Lordship. Lordship, we finally heard the matter.
Why
Lordship, in this case, there is violation of policy condition. There was no road permit, Lordship.
Anyway, my lord, it's covered by my lord, the pay and recover principle, my lord.
But-
Pay and recover principle, anyway, it will cover, the anti-judgment will cover, my lord.
Pay-
Pay and recover, my lord. So, I don't think, my lord, there will be any, by furnishing a bond, my lord, I can maybe allowed to withdraw, my lord. Accident occurred in 2013, my lord.
Hardship.
Yes, my lord.
Of getting after in the 19th method.
Date means
IA
Mal.
third three third three third then five four according for allowing the applicant to withdraw the 50% of the amount of 50% of the awarded by the appellant and that the applicant may be allowed to withdraw the sale. Mr. Sharma for the opposite party, however, submitted granted sometime by the applicant. But the complete learned for the applicant pointed out that the tribunal has ordered to pay and recover. And as such, there is a question of raising action by the opposing party, and the applicant is ready to furnish a bond. But I think some learned from both party is interlocutory application allowed. The applicants are allowed to withdraw 50% of the on furnishing and indemnity on in terms of IH.
Lordship, item number 5, the conduct council is coming up. Mathematics after some. Item 6 and 7. Not 6. It is Lordship. This matter, Lordship, on earlier occasion it was reads regarding Lordship the quantum of challenge, 10,000 rupees is under challenge earlier in earlier Act 173(2). That appeal is not maintainable when quantum is under challenge or below 10,000 rupees. Now it is 1 lakh rupees. That was argued by my council. And on last occasion, I have said that there is an order of this honorable court as a preliminary issue regarding this maintainability when amount in dispute is rupees 1 lakh. And this point has been decided and by this honorable court by Justice B.G. Kotoki in preliminary issue. That case was not reported. That is why I try to collect the certificate to the order. Regarding not quantum, we are not challenging the quantum. We are challenging the liability. So that point has been decided. I could not procure the certificate to the order. So Lordship may take
After
1 week. Lordship.
and agreed by learned advocates of both the parties.
27, 20.
After one,
Item 26 and 27 same.
27 and 28.
27 and 28.
They both councils are also same. Lordship. Councils are also same.
okay, all right.
Lordship. Public.
After one,
27, 28 also.
27.
27, 28. But I am respondent, my lord, wife. The resolution filed by husband, my lord, dismissed. To appeal.
you have a wife.
Right.
So, is there any son for reconciliation? Refer the method to the method.
Attempt may be made. Attempt may be made.
May refer my lord. May try.
Or sir,
You get us.
learn it. Method. This matter is listed under the code. It's subject to the part. The matter is between husband and also now the matter part. According it provides accordingly the part refer to the next list of matter to the it and the party directed to it. Body I could or suggested
Vinegar.
taking the mediator to front or in the part.
My lord, kindly pass out for the timing. He is Mr. DPG in the traffic jam, my lord. May it please your lordship, there has been a delay in this case, my lord. Office note dated 5/8/2025 shows that no edit card or answer
Service not completed.
service is not complete, but in respect to respondent number 6, service is complete. He has refused. That sum.
Third, destroy alternate for the applicant. In view of office note dated 5/8/2025, service upon respondent number 6 being to have completed as he received the notice. Received the- in respect to the other respondent, neither edit card nor answer returned. As is the
Wait for service.
necessary with the matter after doing awaiting service report of on more than 5.
May it please your lordship. My lord, the petitioner is the defendant tenant. I take your lordship to first the plaint filed by them, page 14, paragraph number 2. It is the plaint filed by the here respondent, my friend, here the landlord. Para 2. My lord, may I read it slowly? That by executing an agreement on 1/8/87, the defendant came to occupy one Gumti shop such and such in Tinsukia town, more fully particular described in the schedule of the plaint. The word is as tenant under the plaintiff's father for a monthly rent of rupees only per month according to English calendar month, payable in advance in the first week of each month of tenancy. So it is an admitted fact that it is a relationship of a landlord and tenant. So Mala, the moment landlord and tenancy comes into effect, general law of the Transfer of Property Act does not come into being. We are governed by the special law of Assam Land and Revenue Regulation. This is the plaint, my lord. We, in our written statement, and the another thing that, my lord, in page 15, the only prayer of the landlord in the plaint is that we are the defaulter in making the payment. My lord, your lordship, at para 6, page 15.
Yes.
The cause of action of the suit arose on 13/7/87 when the agreement of tenancy was executed and registered. On 1/1/87 being the date of commencement of tenancy, 1/3/16 being the date when the rent for the month of February 2016 became due and payable by the plaintiff, and all days demand for the rent for the month of February 16 onwards. So they are claiming rent from month of February 2016 as from their plaint. Your lordship has got it. So up to January, they are admitting January 2016, they have received the rent. And the only ground for ejectment of a tenant is on the ground of defaulter. My lord, we filed a written statement denying all this enhancement and others. Ultimately, my lord, your lordship will turn to the judgment of the trial court at page 24. I would take your lordship.
The proprietor's matter is set for admission hearing.
Admission hearing because our execution case has been filed and my lord, next date is on 20 for report.
Can we finally hear the matter?
My lord, because your lordship will find on the very first day when your lordship took up the matter, then there was a order that interim order will be considered. Now execution case we have filed, last day we have filed that document before your lordship. Next day, this order was there, my lord. This order, writ was issued already, my lord. So next date is on 25, next date, 208/25.
Yes, sir. Yeah. Are you ready to finally argue the minute? Ready?
My lord, the suit, ultimately, my lord, your lordship will find the suit in relevant page is page, I will take your lordship to the page 36. Issue whether the defendant is liable to be evicted from the suit premises. Page 36. Trial court judgment. May I read it, ma'am?
Yes.
The issue is the crux of the instant suit. In the instant suit, plaintiff has sought eviction of the defendant on the ground of defaulter in payment of rent. So Then ultimately, my lord, the court held in page 45. Considering all ocular and documentary evidence, this court found that the plaintiff could not prove his case, since the plaintiff suit falls. Plaintiff is not entitled to get any relief in this suit. The suit is accordingly dismissed and disposed of on contest without cause. So the suit was dismissed for the plaintiff. And because exhibit 1, that is the wife of the plaintiff, who is to write in a register, which is the amount she received and what she was not never called in the court. Oh, it was only placed in the court, neither it was exhibited. So due date was never shown. So ultimately suit was dismissed. So my lord, and the case was only for the ground of defaulter. My lord, page 46, your lordship will find defendant's exhibits. Your lordship will find defendant exhibit. Case exhibit A, rent receipt, case from January 18 to March 18. Exhibit B from April 18 to June 18. Then exhibit C from July 18 to September 18 and onwards. Up to, my lord, it is till the case it is continued, my lord, up to 21, 22, 22, my lord. The money all were paid in the rent control court. It was paid by the defendant. Now, my lord, they came for an appeal. Appeal, my lord, I take your lordship, I will not go to the facts again, my lord. I will take your lordship to page 73. My lord, 72, paragraph 13. Paragraph 13, page 72. Sorry, my lord, one thing, my lord. Page 71, the point for determination. Whether the impugned judgment dated and decree passed by the learned trial court in title suit is just and proper or needs any interference in this appeal. And ultimately, my lord, I will take your lordship, page 72, para 13. PW1 has exhibited the agreement dated 1/8/87, entered between the defendant and his father as Exhibit 1. Exhibit the house rent account book as Exhibit 2, and exhibited the relevant entries of the rent receipt. It appears from the Exhibit 2 the defendant has paid rent 700 for the month of January 16. Thereafter, there is no entry in Exhibit 2. Regarding the payment of rent of shop premises, it also appears the Exhibit 2-3 for the month of March 13 started paying rent of 700 per month. On the other hand, it appears from the evidence of defendant, the defendant is admitting the plaintiff as his landlord and deposed that he is paying the rent of rupees 500 per month. The rent was not enhanced to rupees 700 per month. DW has exhibited missed rent case from January 18 to March 23, exhibit D1 to D17. However, defendant has not executed any document to show that he paid rent for the month of February 16 to December 17. Therefore, it appears the exhibit documents the plaintiff and the defendant had not paid for the suit, such and such. Moreover, it appears from Exhibit 1, paragraph 15 is important. Moreover, it appears from Exhibit 1, the agreement of tenancy dated 1/8/87 entered between the defendant and the plaintiff father. The tenancy period had commenced from 1/8/87 and it was executed for the period of 10 years, that is on 1/8/97. The tenancy period agreement has expired. There is no tenancy agreement was executed by the parties till today. It also appears the plaintiff was accepting the rent after the expiry of the tenancy period agreement. However, in case of such and such, the Honorable Supreme Court reiterated mere acceptance of rent for the landlord after the expiry of the period of lease. The whole case of 2005 SCC is on Transfer of Property Act. My lord, pausing for a moment, the moment the Transfer of Property Act would have come, my lord, here it would have been a second appeal. There cannot be a civil revision. This is a civil revision because the relationship of a landlord tenancy is after the agreement is also a statutory tenant. I will rely on a 7 judges Supreme Court judgment, which says 106 of the Transfer of Property Act and others does not rely. It cannot be overruled. It is a 7 judges, my lord. I will place the judge. Rent for the month landlord after expiry of period of lease would not amount to waiver of the termination of lease. So it appears the defendant is residing in the suit premises without any tenancy agreement, as the plaintiff wants to evict the defendant from the suit premises, as there is no tenancy agreement between the parties. The defendant is liable to be evicted from the suit shop. whole concept is, my lord, with due respect, my lord, next, my lord, regarding para 16, regarding issue number 3, issue number 3 was, my lord, issue number 3, whether the defendant is liable to pay 15,400 as ADR of rent to the plaintiff. My lord, and ultimately the court held, paragraph page 75 last. Therefore, as there is no tenancy between the parties, the defendant is liable to pay the amount of rupees 15,400 to the plaintiff as means profit compensation. This is the whole case of the appellate court decides on the premises of 2005 5 SCC, my lord. I had the judgment. It deals with absolutely of, my lord, transfer of property. That is a general law, my lord. And the first judgment that I rely upon, my lord, it is, my lord, 79 Supreme Court 1745. It is a 7 judges, my lord. What is this? Yeah, 79. My lord, at page, my lord, relevant, my lord, your lordship may look into next page, paragraph 4. From there, my lord, they have decided, because previously there were different judgments were there regarding Transfer of Property Act and others. My lord, then from relevant paragraph 4 onwards, it has said, we shall presently refer the various decisions of High Court and this court taking contrary views. But before we do so, we make some general observation. It is well known that after the Second World War, to give protection to a tenant against unnecessary, undue, or unreasonable eviction, and in the matter of being exploited for payment of exorbitant rent, all states in India at one time or the other passed Building Rent or Control Act. Amendment in them were brought about from time to time. The language of and the scheme of the acts varied and differed from state to state. Even though there was no basis or fundamental difference in regard to law of eviction of a tenant in any of the state statutes, different construction were put in regard to them, and principles were called out in varying manners to arriving at the conclusion in some cases that a notice to quit in accordance with 100 section 106 of the Transport Property Act was necessary. In some, it was held that it was not necessary. The gravamen of the underlying principle seems to have been overlooked in many cases. Under the Transfer of Property Act, the subject of lease of immovable property is dealt with in chapter section 105 defines the lease, the lessor and lessee, and the rent purely as a matter of contract. A lease comes into existence under the Transfer of Property Act. But in all social legislation meant for the protection of the needy, not necessarily the so-called weaker section of the society, as is commonly and popularly called, there is appreciable inroad on the freedom of contract, and the person becomes a tenant of a landlord even under his wishes on the allotment of a particular premises to him by the authority concerned. Under section 107 of the Transfer of Property Act, a lease of immovable property from what year to year or for any term exceeding 1 year or reserving a yearly rent can be made only by a registered instrument. None of the State Rent Act has abrogated or affected this provision. Section 108 deals with rights and liabilities of lessor and lessees. Many state rent acts have brought about considerable change in the right and liabilities of a lessor and a lessee, largely in the favor of the latter, although not wholly. The topic of Transfer of Property Act, other than agricultural land, is covered up entry 6 of list 3 of the 7th schedule of the Constitution. The subject being is a concurrent list. Many state rent acts have been necessary implication, and many of them by starting certain provisions with a non-obstantive clause. Our Urban Area Rent Control Act, Section 5, also starts with a non-obstantive clause, bar against ejectment of a tenant by either two grounds, bona fide ground or defaulter. That also starts with a non-obstantive clause. Have done away with the law engrafted under Section 108 of the Transfer of Property Act, except in regard to manner which was provided in the State Act. Such and such manner I skip over, and ultimately, my lord, the court held in para 8. My lord, before we embark, may I read it, my lord? Para 8. Before we embark upon review of some of the decisions of this court, we think it necessary and advisable to briefly refer to the provisions of some of the State Rate Act in support of the observation made by us above that on the question of notice, no different result is possible on the language of State Act Section 10 of Tamil Nadu Rent Act. A tenant shall not be evicted whether in execution of a decree or otherwise, except in accordance with the provision of this section or section 14 to 16. My lord, then ultimately next is the para 9 with Bombay Rent Control Acts. And ultimately, my lord, the court held my lord, para 18. Lastly, our attention was drawn to the decision of the court of such and such. The lease in that case had come to an end by a flux of time. A tenant continued in possession and becomes a so-called statutory tenant. My lord, I become a statutory tenant and I cannot be evicted without a decree from the civil court. That is under the Rent Control Act. The argument put forward before this court was a fresh notice under 106 transport was necessary, was rejected on the ground. Having examined the matter on authority and precedent, it must be frankly confessed that no other conclusion is possible on the first principle. Lease of urban renewable property represent a contract between lessor and lessee. If a contract is put to an end, it has to be terminated by a notice to quit as envisaged under 106 of the Transport of Property Act. But it is equally clear as provided under section 111 of the Transport of Property Act. The lease of immovable property determines the various modes therein prescribed. Now, if a lease of immovable property determines in any of the modes prescribed under section 111, the contract of lease comes to an end and the landlord can exercise his right of re-entry. The right of re-entry is further restricted and referred by the provisions of Rent Restriction Act. Nonetheless, the contract of lease has expired and the tenant lessee continues to be in possession under the protective wing of the Rent Restricting Act until the lessee loses protection. But there is no question of terminating of contract because the contract comes to an end when the lease determines in one of the most prescribed under section 111. There is therefore no question of giving a notice to quit into such a lessee who continues to possession after determination of a lease. After the contract comes to an end under the protection of the Rent Restriction Act, if a contract comes to an end, there is no question of terminating contract over again by a fresh notice. If we agree with the view that determination of lease in accordance of Transfer of Property Act is a condition precedent to the starting of a proceeding under the State Rent Act for eviction of a tenant, we could have said so with respect to the view expressed in the above passage is quite correct, because there is no question of determination of lease again once it was determined by a flux of time. But on the first assumption, we have taken a different view of the matter, and we have come to the conclusion that determination of a lease in accordance of Transfer of Property Act is unnecessary and mere surplus because the landlord cannot get eviction of a tenant even after such determination. The tenant continues to be even thereafter. That being so, making out a case under the Rent Act for eviction of a tenant by itself is sufficient and it is not obligatory. This is 7 judges. And my lord, the appellate court relied on 2005 5 Because, my lord, I have read the plaint where your lordship will find they have admitted between landlord and tenancy. And under the Urban Area Rent Control Act, my lord, they have accepted my rent as per their plaint is up to February 2016. And this is a 2 judges bench which deals with Transfer of Property Act 116. Had it been a Transfer of Property Act, we would have come for a second appeal, man. Because that is a 7 judges bench which holds that even a tenancy can be created, but not implied. as per the Urban Area Rent Control Act, my lord, it can be implied also. There is no need of, my lord, of an agreement. And moreover, my lord, there is the perversity where they have said in their plaint that February 16, we have received the rent. And now the appellate court held that after the expiry of 10 years, from 87 to 97, my lord, the agreement is not there, you can be evicted. That itself is the perversity in the appellate court judgment. And my lord, as regards another issue, my lord, it came to my mind, my lord, where my lord, your lordship will find para 14, para 14, page 73.
Of
My lord, page 73. My lord, para 14. On the other hand, it appears from the evidence of the defendant is admitting the plaintiff as his landlord and deposed that he is paying rent up to rupees 500 per month. The rent was not enhanced to rupees 700 per month. DW1 has exhibited in Miss Rent case from January 18 to March 23, exhibit D1 to D17. However, defendant has not executed any document to show that he paid rent for the month of February 16 to December 2017. Therefore, it appears the exhibit document for plaintiff and the defendant had not paid rent for the month of such to such. Moreover, moreover, the exhibit, that is the agreement. And my lord, as regard in para 17, para 16, my lord, sorry. The court held, my lord, in middle portion, thereafter no tenancy agreement was executed by the parties till today, and the defendant is residing in the suit premises without any tenancy agreement. As per evidence of the plaintiff, the rent for February 16 to December 17, in the case of such and such, it was held the Supreme Court that the tenant, while continuing the possession after the expiry of the lease, became liable to pay mains profit. Therefore, there is no tenancy between the parties. The defendant is liable to pay the such and such as mains profit. The court held there is the question of area rent does not come. It is only mains profit. The court held that is the mains profit. And my lord, as regards in the trial court, my lord, your lordship will find I have given the documents by exhibiting the documents, my lord. Page 46, I have shown all my defendants exhibits, my lord. I have given all the exhibits that I have paid rent. And my lord, in this, my lord, and the trial court held in one portion, my lord, page 42. Page 42, my lord. Second line. The first line, my lord. DW1 has deposed in evidence, page 42. The defendant has deposited rent at the rate of 500 to plaintiff from January 2017 to November 2017. On perusal of Exhibit A, R, it appears the notice were duly issued against the plaintiff, which were refused to receive by plaintiff. Said exhibits were also accompanied by a copy of money order. PW has deposed that no notice of deposit of rent was received by him. My lord, this is for the month of January 17 to November 2017. And the court held my lord, page 73. page 73, my lord. Para 14. However, defendant has not executed any document to show that he had paid rent for the month of February 16 to December 2007. Again, my lord, this here, Exhibit A. This is perversity, my lord. And my lord, if your lordship can look into the Urban Area Rent Control Act, my lord, your lordship is well aware of the facts that, my lord, here, Section 5 starts with the non-obstantive clause, bar against passing and execution of degree orders for ejectment. No order, my lord, the order, number 1 says, no order or decree of recovery of possession of any house shall be made or executed by any court so long as the tenancy pays rent to the full extent allowable under the Act and performs the condition of the tenant. And I become a statutory tenant, my lord. A statutory tenant gets the all protection under the Urban Area Rent Control Act, and I can only be ejected by a decree from the court, and which is in accordance to law. My lord, one judgment of 85 Supreme Court, my lord, your lordship may look here where they quote para 36 and 37, my lord. I'm giving them. Yep. 85 Supreme. There are 36 and 37. Here, may I read, my lord, slowly? Accordingly, you hold that if Rent Act in question defines para 36, my lord. Last page, my lord, this.
Yes.
No. Accordingly, you hold if the Rent Act in question defines a tenant in substance to mean a tenant who continues to remain in possession even after the termination of the contractual tenancy till a decree of eviction against him is passed. The tenant, even after the determination of the tenancy, continues to have an estate or interest in the tenanted premises. And the tenancy right, both in respect of the residential premises, should be premises, and the commercial premises are heritable. The heirs of the deceased tenant, in the absence of any provision in the Rent Act, to the contrary, will into the position of the deceased tenant, and all the rights and obligation of the deceased tenant, including the protection afforded to the deceased tenant under the Act, will devolve on the heirs of the deceased tenant. As the protection afforded by the Rent Act to a tenant after the determination of tenancy and to his heirs on the death of such tenant is a creation of Act for the benefit of the tenant, it is open to the legislature which provides for such protection to make appropriate provision in the Act with regard to the nature and extent of the benefit and protection to be enjoyed and the manner in which the same is to be enjoyed. If the legislature makes any provision in the Act limiting or restricting the benefit and the nature of the protection to be enjoyed in a specified manner by a particular class of heirs of the deceased tenant or any condition laid down being fulfilled, the benefit of protection had necessarily to be enjoyed on the fulfillment of the condition in the manner and the extent stipulated in the Act. The legislature, which by the Rent Act seeks to confer the benefit on the tenant and to afford protection against eviction, is perfectly competent to make appropriate provision regulating the nature of protection and the manner and the extent of enjoyment of such tenancy right after the termination of the contractual tenancy of the tenant, including the rights and the nature of protection of the heirs on the death of the tenant. Such appropriate provisions may be made by the legislature, both with regard to the residential tenancy and commercial tenancy. It is, however, entirely for the legislature to decide whether the legislature will make such provisions or not. In the absence of any provision regulating the right of inheritance and the manner and extent thereof, and in the absence of any condition being stipulated with regard to the devolution of tenancy, the rights on the heirs of the death of the tenant, the devolution of tenancy right must necessarily be in accordance with the ordinary law of succession. Ultimately, my lord, para 38, we must therefore hold that such and such enjoys the status of a tenant of the premises in the dispute even after the determination of the contractual tenancy, notwithstanding the termination of the contractual tenancy. Vasti Ram has a estate in the interest of demised premises, and tenancy rights of Wasiram did not come to an end with the death, but devolved the years and legal years of present. This is my whole, the appellate court whole premises is that 87, 97, thereafter no tenancy, you go up. And regarding that period that there was no exhibit, exhibit A, the trial court held that exhibit A was there. A to R. Right.
Yes. So, yeah.
What I could perceive from the argument of the main method is all challenging the observation of the appellate court that because of the determination of the agreement after 10 years with effect from 87, there is no agreement. So since then, the tenant is liable to be evicted. So that portion of the appellate judgment is only challenged, but he has not said anything about payment of rent with regard to the month of February 2016. Now from here and there, he's trying to show that he has exhibited those, but in the evidence on affidavit of the defendant number 1, your lordship will find he is relying on the rent receipt from 2018, not beyond that.
Up to 2000.
From on and onwards from 2018, those were deposited in the court. Evidence on affidavit. So therefore, the appellate court has rightly said that there is nothing to show that he has paid rent from February 2016 to December 2017. And it's a clear finding of the appellate court that there's nothing on material to show that he has paid rent for the month of February 2016. Now the trial court has dismissed this suit on the ground that there is no due date. Appeal was prepared, the due date has been, considering the due date, the finding has arrived there. Now from the pleadings of the parties, if your lordship will kindly see the paragraph 2 that has been read out at page 13. Relevant page 14. I'll just once more I'll just read out page 14 is a part of the plaint. It's only to understand what is the pleaded case, my lord. No amount of evidence beyond the pleading can be, my lord, looked into, my lord. Here, my lord, clear admission that there is an agreement. It's a clear admission that I am the landlord. I have said that as per the agreement, in the plaint, I have said as per the agreement, the rent fall due on the first week of every month. But he started paying in the second week of the succeeding month. That your lordship may kindly come to page 14, paragraph 2. That by executing an agreement dated 1/8/1987, the defendant came to occupy one Gumti shop premises measuring 8 feet into 13 feet by 6 feet approximately, having wooden wall and CIC roof, equipped with electric fittings, standing on the land including in Dag number 1145, covered by PP number 1988 of Tinsukia town in Moja, Assam, more fully particularly described in schedule so-and-so, as tenant under plaintiff's father at a monthly rent of 350 only per month according to English calendar month, payable in advance in the first week of each month of tenancy. However, the defendant was most irregular in the payment of the due rent, and he paid the rent only by the end of the second week of the month succeeding to the month of tenancy. This is my specific case, my lord. This has been replied in para 8 of the written statement as page 19. he denied so far as subsequent part is concerned. He said, I pay on the first week of the month which it fall due, paragraph 8. That in regard to the paragraph 2, the same is partly admitted and partly denied. It is admitted that one agreement dated 1/8/87 was executed between the defendant and the predecessors of plaintiff, but it is strictly denied, being false and frivolous, that however, the defendant was mostly irregular in payment of the due and he paid the rent only by the end of the second week of the month of succeeding to the month of tenancy. The said premises is subject matter of this suit and is hereby called the suit premises, thereby putting the plaintiff to prove the same said denied part in a legal manner. Then in paragraph 9, my lord, we find that the contents paragraph 3 of the plain being not in the specific knowledge of the answering dependent, as such the same is denied. However, it is admitted that the plaintiff is the landlord of the answering dependent. So landlord is admitted. Now, continuation of this paragraph 8, my lord, that he has admitted the agreement, and exhibit 2 is the agreement where it is clearly mentioned what is the due date on which, my lord, the rent has to be paid. My father's statement in the plain that he has started paying in the second week of the succeeding month, that has been denied and put to proof thereof. And in continuation of this, your lordship will come in the next page, page 20, the second paragraph, the sub-parameter rather. It is submitted that the initial rent fixed was 350 per month, and during the period the rent was enhanced only on one occasion and was fixed at rupees 500 per month payable to the plaintiff. The defendant has been regularly paying rent rupees 500 per month after enhancement to the plaintiff, and rent up to December 2017 has been duly paid, being the last rent paid on 3rd December 2017. So for the month of December also, he has paid on the 3rd day of the month of December. So there is no confusion with regard to the due date. Though I had said that he started paying in the second week of the succeeding month, but he is categorically so no, I don't know that portion has been denied. Now in the evidence, if you for the first time he has come up with the plea that on different dates I used to pay, there was no due date. So people, can you see the evidence on affidavit of the respondent number 1? Evidence on affidavit mirror dated 27/4/2020. I'll just take out, I'll not take my note, only one.
DW1.
DW1.
DW.
Look.
Yes.
Paragraph 4, my lord. That on 3/12/2017, I
Cross-examine.
no, my lord, evidence on my lord, the chief, my lord, evidence in affidavit
Paragraph 4.
dated 27/4/2023.
Yes.
Paragraph 4.
Yes.
That on 3/12/2017, paragraph 4, my lord. That on 3/12/2017, I had paid the rent amount of rupees 500 for the month of December 2017 to Mohammed Jahil Haq. Similarly, I had also made the payment of the due rent for the month of January to 2017 to November 2017 on different dates according to my convenience, which was accepted by the plaintiff. This is beyond the pleading. It is not a pleaded case. That I had also made the payment of the due rent for the month of January 2017 to November 2017 at different dates according to my convenience. It is first time this plea has been tried to done by way of this affidavit. They have tried to bring in, and the evidences, documents they are relying, my lord, will find paragraph 10. That I rely on the following documents to prove my case. So no document admittedly from the February 2016 to 2017. Now his version again changes during the cross-examination. Let me kindly have a look to the cross-examination part of the cross-examination of it. Married. I'll just read now. Jahol Haq is the landlord. Earlier, his father was landlord of Shop House, which was let out to me. Exhibit 1 is tenant agreement entered between me and plaintiff's father. As per Exhibit 1, said tenancy is still in continuation. Exhibit 1 to 1 shows our signature. Said agreement was registered with sub registry and I put my signature and thumb impression before the sub registry. Exhibit 1 is signature put before the sub registrar. I have signed Exhibit 1 after understanding the content of it fully. I don't know since when the rent is claimed to be due. I myself used to go to pay the rent of the suit premises to the plaintiff, his parents, to his wife. I used to pay rent before 15 days of each month. I do not know till when I paid rent to plaintiff directly, and I cannot say since when I am depositing rent in court. So this is a second plea they have come up, Miller. That a third plea that he is to pay the the rent in the second week of the succeeding month. So what is what contended by the plaintiff in the plaint? Has you also got it? My specific case is this is the agreement, rent fall due on the first day of on the first week of the month for which rent is to be paid, but they have started paying in the second week of the succeeding month. In the written statement, they said, no, we pay rent only on the first week of the month for which the rent fallen due. Then in the affidavit in opposition, they have further come with a plea that there was no due date. I conveniently I pay and he used to be accepted. So mere acceptance of rent, whether my lord, the legalize his continuation in the position. That was the question for which my lord, the appellate court has referred to the judgment. My lord. Now, in the this cross-examination, they have come up and said that the second week of the succeeding 15 day of the succeeding month, we pay rent. So that is the my lord, whole case, my lord. Now, where is the perversity of my lord, the any palpable illegality my lord, shown in the judgment while holding him as a defaulter, and he has failed to show anything that he paid rent for the month of February 2016 onwards. So far as I am concerned, Lordship has have seen the pleading. So to substantiate that, he has not paid the rent, I have given a books of account. That books of account is maintained by my wife. It was marked as an exhibit, and in my evidence, Your Lordship will find evidence on affidavit. I have also marked, my lord, exhibited that that books of account as exhibit 2, exhibit 1. Now, after allowing, my lord, the document, the books of account to be exhibited without any protest, my lord, can they challenge the, my lord, admissibility of that, my lord, particular exhibit? That should have been, my lord, objected to that. They have accepted that. From the trend of cross-examination, Your Lordship will find that whether it is correct or not that much, my lord, they have been showing, if I, Lordship, my lord, take up to the, my lord, cross-examination of the DW of PW1, my lord. So that is, my lord, basically, my lord, that will not come, my lord. What I wanted to contend, that so far as I am concerned, I have given some evidence. It's a preponderance or probability. What evidence you have showed, my lord, that you have paid the, my lord, rent for the month of February 2016. To contend that only, my lord. And also, under this evidence on affidavit of the PW1,
Yes, paragraph number.
my lord, will find page 3. Exhibit 2 is the house rent account book. Exhibit 2 is the 11 entries of rent paid by defendant to the month of January 2016. Exhibit 2.2 is the entry dated so showing payment of rent since the month of October 2019. Exhibit 2 is the entry dated so and so, exhibit so and so. It's only maintaining an account, nothing else. It is not a rent receipt or something to be proved by the maker of it. And this was also not, my lord, will find the cross-examination part. Nowhere, my lord, it has been, my lord. As you also got the cross-examination part of PW1. As you also. Last portion, exhibit 2 does not mention page number. Exhibit 2 is maintained by my wife, Ms. Sahija Khatun. Money is collected either by me or by my wife. I do not know any Sue Nandan. I do not know P. Singh, who mentioned in Exhibit 2 as who had collected rent in that particular month. Exhibit 2A is the relevant entry of receiving rent for the month of June 2008 from the defendant. The entire reflects of 500 received as rent, area of rent. I cannot say. So, there's no, what has been alleged now, it has never been, even cross-examined also, or not put any suggestion that this is not a book of account, etc. Of the for so that is the case, if the appellate court having found the defendant present petitioner as the defaulter and having failed to show any payment of rent from the it's a right decree that has been passed. It's a suit of 2017. The 10 years gone by. So therefore, poor man, living only the earnings of the rented house.
Allowed with the lordship permission, only a small reply. Page 14 of the plaint. The first thing is this, my lord, that page 14, paragraph 2 of the plaint, my lord, May I read it, my lord?
You have already read.
My lord, that's important because that submission, what my friend has given, is contrary to the law laid down by this court. My lord, that is why I want to place it, my lord. A tenant under the plaintiff father monthly rent only per month according to English calendar month payable in advance in the first week of each month of tenancy. However, defendant was most irregular in the payment of due rent, and if he paid rent only in end of second week of the month succeeding to the month of tenancy. And paragraph 4, same line was there, where my lord, the plaintiff, then my lord, in the middle portion, he said the defendant paid rent for the month of January 2016. So, my lord, up to 2016, this irregular way of making payment was accepted by the landlord. And this is the judgment of this court, my lord. My lord, paragraph 7 and 8. 1989 to GLR page 7, my lord, para 7 and 8. And my lord, another submission that I will place it, my lord, your lordship will find, para 8. May I read it, my lord? In the instant case, the point which arises for consideration is whether the landlord failed to prove the existence of two conditions, and the court below erroneously decreed the suit for wrongly throwing the burden of proof on the tenant. I have carefully considered the submission of the petition. It is well settled by a series of decisions of this court that the existence of a condition precedent for passing an order in question must be proved by the landlord who claims eviction of a tenant. A mere statement of the landlord that a tenant is a defaulter or that the house in question is required by him for his own use or occupation is not sufficient. He has to establish the aforesaid condition by cognate and convincing evidence. If he fails to prove the existence of any of the aforesaid conditions precedent, the court cannot pass an order of eviction. In a case where eviction is claimed on the ground of tenant being a defaulter, within the meaning of clause E of the proviso of subsection 1 of the section 5 of the Act, the landlord has to prove the tenant failed to pay the rent lawfully due for him in respect of the house within a fortnight of its falling due. The most important fact that has to be proved, therefore, is the date when the rent actually fell due. Without determination of a aforesaid fact, the difficult or rather impossible to hold tenant defaulter, because in that case, the where starting from for where the period of a fortnight within which the rent has to be paid runs in does not available. The determination of the date when the rent actually falls due in the particular case depends upon the arrangement of the agreement between the parties. The rent may be fixed on monthly basis, but that by itself will not indicate the date and the rent will fall due. The parties might mutually agree that the rent would be paid monthly, say within a week or fortnight or a month or any other interval after the expiry of the month for which it is due. There may be a case where no due date is fixed between the parties and the payment of rent, and the rent is paid on demand of the landlord from time to time. There may be cases where landlord, due to various reasons or for his own convenience, wants the rent to be paid in 2-3 months at a time, either in advance or expiry of the period for which it is due. There may also be cases of the landlord reside in some place far away, such and such, but would be paid from time to time, and when he visits the town, demands such and such. Such contract or arrangement was not unknown or uncommon, nor they are always writing. Landlord has therefore to prove by adducing a suitable evidence as to when the rent fall due. When there is no agreement in writing, then ultimately the court held, my lord, if he keeps on accepting the rent irregularly, now he cannot turn around and say that. Ultimately, the court held that a middle portion, a landlord who continues to receive the rent at varying intervals from the tenant without any objection whatsoever for several years cannot be permitted to suddenly turn back and say that the arrangement between him and his tenant was otherwise and seek eviction of a tenant on the ground that he was a defaulter. That is, my lord, page, this is middle portion of this page. Your lordship has got it. There, my lord, now another thing, my lord, the trial court held that exhibit 1, the author has not come to prove it. So by mere producing, it cannot be proved. Exhibit 1. Exhibit 1, 2. So, my lord, your lordship will find in the trial court's order. Case, then my lord, your lordship will find in that relevant portion. And page 39 also, your lordship will find. middle portion, para 34. PW1 stated the rent was due from February 16, but defendant claimed the rent was paid up to December 17. It is mentioned OT that Exhibit 1 mentioned that receipt was supposed to be issued on payment of rent, but PW1 in cross-examination has clearly deposed he never issued any rent receipt. PW1, although deposed that initial rent was such and such, this was enhanced, but PW has not disclosed on what basis calculation of the enhanced was closed.
Which part you were reading? Paragraph number?
34. Middle portion.
Page number?
39.
Yeah.
Middle portion, my lord, para 34. It is mentioned OT that Exhibit 1 mentioned the receipt was supposed to be issued on payment of rent, but PW1 in cross-examination has clearly deposed that he never issued any rent receipt. And my lord, I skip over to page 40.
Yes.
Middle portion again, my lord. PW1 also deposed that his wife Sajida Khatun maintained Exhibit 2. However, wife PW1 was not even examined. It is a trite law that mere marking of exhibit does not prove the document. Defendant side during argument has rightly made submission without examining the author of Exhibit 2. The document is not proved even. So this portion was never discussed by the appellate court, that whether that has to be set aside by the appellate court. The appellate court never discussed this. So that remains a finality. Exhibit 2 was never proved. Where is the discussion of the appellate court on this matter? This portion was by the trial court. Their suit was dismissed, and this was never discussed by the appellate court as regard Exhibit 2. That it cannot be done or such and such that has been proved. Nothing has been.
Exhibit 2 is the book of account.
Exhibit 1, my lord, Exhibit 2, your lordship will find page 40. PW1 has deposited that Exhibit 2 maintains Exhibit 2. That Exhibit 2 is page 46, your lordship will find what is Exhibit 2. Is house rent account book.
Yes.
Exhibit 2. That was never proved.
How did the book of account has to
Well, that the original has to be proved, and the author has to come and say that I have written that the wife never came before the court. The author of the document has to come before the court and say.
Is it the mode of proof of that document?
And that is the mode of proof, but it was by just placing it that my lord, even a letter, signing of a document does not prove the contents of it.
Signing of a document and a being of a book of account is different.
But the wife never came before the court. And the appellate, whether there is any discussion.
Have you cross-examined the PW1 on this point?
My lord, here your lordship will find the PW1 exam. Because it was in my favor, my lord, it was the court.
I am not asking you.
Because the court held.
Favor or other.
My lord, PW1.
My point is whether you have cross-examined the PW1.
My lord, in the PW1's evidence, my lord, I am reading the PW1.
Not necessary to repeat the same thing.
My
We
lord.
have some other matters.
My lord.
You cannot spare so much time for it.
My lord, then, my lord, because in the evidence he said, my lord, this was just exhibited, but he never proved the wife. He said that the wife maintained the Exhibit 1, and the wife never came before the court. That is his admission, my lord. Was it necessary for me to go for cross-examination?
Okay, that's why your cross-examination on that point is not required.
Because wife,
that is your submission.
My submission, because and my lord, appellate court has not held anything in contrary to the trial court judgment. No discussion on that.
Yeah,
Best.
Mr. Sopoa
My lord,
will take a break of 5
my lord, my lord.
Oh.
No problem, no problem. My lord, this is the second appeal, my lord, against the judgment of the civil judge passed by Civil Judge Dibrugarh, my lord, before going to the impugned judgment.
Yeah.
The
further the substantial question of law.
yes, my lord. That is at my lord. Page 4, my lord. Whether the learned first appellate court are in applying the provisions as laid down under orders 7, Rule 7 of the CPC and travel beyond its scope. Whether the first appellate court are in law solely considering the exhibit number so and so in support of title over the suit land.
These are the ground
Yes.
where the question of law.
The question of law, that is the question of that it has traveled beyond the scope, whether it is
The
correct.
grounds and the substance of or
Are not exactly same, my lord, in my
but
understanding.
yesterday the verdict
Pardon, my lord.
yesterday that was the direction given to
My lord, my lord. My lord, these are the questions that we have suggested, my lord. This is proposed from our side, my lord. Ultimately, my lord, this court has to frame depending upon this suggestion.
right. But with the grounds and the
My lord, questions are based on the grounds, my lord.
that's why where is the question?
This one, there are we have suggested only 3 questions. That is at page 4, my lord.
One, two, three.
Yes, page 4.
Okay.
My lord, has your lordship taken up this amended appeal memo?
Yes, page number 4. There are three
3, 1, 2, 3.
One.
Yes.
okay. For referring to
My lord, page number 4.
no.
Thank you.
No, you were reading something.
Yes, I am reading these questions. Yes. Whether the learned first appellate court are in applying the provisions as laid down under Order 7, Rule 7 of the CPC and travel beyond its scope.
What order 7 to the
My lord, Order 7, Rule 7 is the relief that has been pleaded. Whether that can be molded in a manner which changes the character and the nature of the suit. Here it has happened like that it was never pleaded in the plaint. The plaint was for,
let us go through the
my lord,
page number.
plaint is at page, my lord, 9.
The pairs in the plain last part.
Yes, my lord. Last part is at page 17. The plaintiff therefore prays for decree against the defendants for area dues of rent amounting to rupees 1,821.60 paisa from 1/10/1950 to 31/9/2004 and for a perpetual injunction against the defendants to restrain the defendants, their workers, employees, etc. from constructing any structures on the suit land by damaging the old Pakka building thereon. And the cost of the suit and any other relief. In this, any other
What
relief.
is the relief granted by the
Sir,
appellate court?
yes, that is what I'm trying to say. That is the first appellate judgment started page 52, my lord. Sorry, I'm so sorry. The first appellate court judgment started 63, my lord. 63, and the
relief granted.
relief granted is last part.
78.
Page 78. It is hereby declared that the appellant plaintiff Muhammad Kamaluddin Ahmed and pro forma defendants, namely so and so, are the recorded pattadars of the suit land having right, title, and interest thereof. The principal respondent defendants shall pay due compensation to the plaintiff and pro forma defendants for the use of occupation of the suit land since 1950. Well, I will appreciate cause of action arose in 1950. Suit was preferred in 2005. This Article 52 of the Limitation Act and has given a total go by. In calculating the compensation in lieu of the rent, the defendants may obtain instruction from an expert in this regard so that fair rent for that area would be calculated as per the market rate. As admitted during argument, kindly see, as admitted during argument, there is no pleadings. What is the role of lawyer to argue and the court takes cognizance while arguing something if it is not on record? As admitted during arguments, a portion of the land after the suit land is lying vacant. In the interest of the public service, it is directed that the defendant shall deliver the vacant portion of the vacant land out of the suit land to the plaintiff and pro forma defendants within a period of 2 months from today by making proper measurement and boundaries. Oh, it was not prayed, my lord. It was never prayed. The defendant shall also demarcate the,
That is part of the
pardon me, lord.
part of the suit land.
Yes.
That vacant land is a part of the suit
But there is no pleadings as such. Neither it is prayed.
2 because of.
land. No, there is the pair number.
See the vagueness of the,
land.
kindly see the vagueness of the, so vague this portion is. As admitted during the argument, it is not from the pleadings. A portion of land out of the suit land is lying vacant. A portion of land. Where? This side, that side, east, west, north. In the interest of public service, it is directed that the defendant shall deliver the vacant portion of the vacant land out of the suit land to the plaintiff and pro forma defendants within a period of how much portion that I have to give? No, is this decree executable? No. The defendant shall also demarcate the land over which its office is running, and thereupon after ascertainment, they shall pay the price thereof to the plaintiff pro forma defendants. In deciding the price of the land used for their office, they shall take into account the rate as per the Land Acquisition Act. In demarcating the area used for the office of the Assam State Corporation, State Transport Corporation, and the vacant land, the office of the Deputy Commissioner Dibrugarh, considering the greater interest of the public, shall depute one senior officer from the establishment to do the needful in this regard. On receipt of such payment, the plaintiff and the pro forma defendants, as well as their respective representatives, in any character, shall execute formal deed of transfer into the same in favor of the ASTC Moran. The defendants and their representative in any character are hereby permanently restrained from making any construction over the vacant land out of the suit land. As the consequential relief in respect of the payment of money is granted in view of Section 7(4) of the Court Fee Act, it is directed that the pro forma plaintiff and pro forma defendants shall pay proper court fee on the money that would be received by them from the defendants. This disposed of the appeal on contest, prepare a decree. Well, it has changed the whole character of the plaintiff, which is not permissible in law. And the,
There is a third pair in the plane.
that is what?
Any other
That is the scope of section Order 7, Rule 7. It is no longer a res integra right now, my lord, that while taking guard of the section Order 7, Rule 7, the prayer cannot be molded in a manner that changes the character of the suit. This was a suit, money suit, simpliciter. This suit was a simpliciter money suit, That is why we are resorting to a regular second appeal, otherwise it would have been a CRP. It is not a suit under the special act of the Assam Rent Control, Assam Urban Areas Rent Control Act. No. It is a simply suit or money suit. Only because that the permanent injunction has been prayed for, this has been registered as a title suit. Otherwise, it would have been a simple money suit only. But be that as it may, my lord, where is the scope of the learned First Appellate Court to convert the whole suit into taking to a different aspect altogether? That too, let us read the first judgment title suit, judgment passed by the the first magistrate, my lord. Judgment of the title suit, my lord. That starts at page 52. See how this was, the suit was conducted there in Malta, and how the lacunas were filled up at the first appellate stage. This will prove, my lord. The present suit is for, that is starts at page 52. The present, has your lordship got it?
Got it.
The present suit is for recovery of the area rent and for perpetual injunction. The plaintiff case in nutshell is that originally Paziruddin Ahmed was the pattadar in the possession of land measuring so and so periodic patta 86, situated in Moran town, Moran Moza district, Dibrugarh, and prior to his date, he entered into an agreement with the defendants, and as per the terms and conditions of the agreement, he delivered a plot of land measuring 2 bigha covered by dag number 199 of the periodic patta number 66, situated in Moran town for utilizing the same as bus stoppage of ASCC for a rent of rupees 33.12 paisa per year. In the month of September 1950, the defendants being the tenants of his tenant of his father, it could have been
Okay,
father.
My lord, that is one of your or one.
Yes.
And there's the other.
Regarding the other two, my lord, that is why I was reading the judgment, my lord. Here it is, this exhibit 1, 2, 3, 4.
Other to the aspect of fact.
No, why I'm saying this, my lord. This exhibit 1, 2, 3, 5, and M, it is non-est. It is not existed in the court. That is was observed by the London Munsif in the judgment. There is no exhibit M ever exhibited by the defense. This finding is in the judgment of the learned Munsif. That is what I am trying to show. If your lordship can come to
M is not there. Come to page number 61.
yes, my lord.
Everything.
M is not there. Last is L.
L.
See the list of exhibits. List of plaintiff exhibits 1 and 2. And list of defense exhibits up to L. It is non-existent. They did not exhibit anything. Learned Munsif held, my lord, that though there is mentioning of exhibit 1, 2, 3 in the evidence and affidavit, but it was neither exhibited nor marked. But suddenly, it has been marked and exhibited, declared to be as exhibited in the first appellate court. It cannot be. They would have filed a review petition saying that these are marked. Why have you said this?
Okay. Without frame of the first one and the last one.
My lord.
Then if at the time of
Yes. Lordship may stick to 1 and 3 also. And in
One
2, yes, in
then
2,
the does
My lord, the only submission is that, my lord, whether that's a sufficiency of evidence is a subject matter in second appeal, my lord, because first appeal is the, my lord, page just for evaluation of evidence, my lord, available before the honorable learned court below in trial court, and what is before the, my lord, appellate court. Now, my lord, this so far this is concerned,
the line,
Mal.
the
Yes.
prayer put.
Yes. It
And
is for my lord
also
composite
the delay
prayer.
is granted by the appellant.
Mal.
So some of the delays granted by the appellate court was not rightful in the line.
Mal, even then, my lord, if lordship once again goes to that order 7, rule 7, my lord, that power is there. Kindly see, my lord, every plane, order 7, rule 7, on what my friend is trying to make a question of law. My lord, every plane shall state specifically the relief which the plaintiff claim either simply or in the alternative, and it shall not be necessary to ask for general or other relief which may allows be given as the court may think just to the same extent as if it had been asked for. And the same rule shall apply to any claim by the defendant in his written statement. Now, apart from the, my lord, specifically prayed for also, that power is there before the honorable court if it is come from the, my lord, evidence and the plea. Now, even if it is not there in the pleadings, if it is come from the evidence, that can be considered while granting the relief, my lord, as per order 7, rule 7. So therefore, if the learned court below has granted, my lord, directed for delivery of possession, because being the tenant, he cannot ask, question my ownership over the land. He cannot. The owner's title cannot be, my lord, questioned by the, my lord, tenant. Now, thing is that, my lord, he has already accepted my title because admission on the part of the appellant is at page 29. As to the title of my father over the land, page 29, they just said in the written statement that your name, sir, because we are the sons and daughter of Farajuddin, he expired. That agreement is not between you. Agreement was with your father, so you are not entitled. This is their case, my lord. Page 29, kindly have a look, just small paragraph, my lord. From the, my lord, fifth line, page 29. In this connection, page 29, my lord, started from the top fourth line, fifth line. In this connection, it may be stated herein. Internal page 4, this is above
Lord,
paragraph 13, my lord.
Just exactly below the number 29. Just exactly below the number 29.
Yes.
Page number 29. Where it is written 29, just exactly below that.
Page 29,
Sentence start
fifth
with
line.
in this connection.
Page 29 of the memo of appeal.
Memo.
Yes. Lining.
It is,
You tell me the paragraph number.
My lord, it is continuous paragraph from para 12.
Okay.
And your lordship will find from page 99 top,
29.
fifth line, my lord.
29.
Page 29. In this connection,
Okay. Yes.
in this connection, it may be stated herein that from the certified copy of case map, CITA of the said plot of land issued by the Circle Officer, Revenue Circle, Moran, it is revealed that bus station ASTC Moran is established on the plot of land measuring 2 bigha, covered by Doug number so-and-so of Moran town, Moza, and Patta has been running in the name of Farajuddin Ahmed, Simoti so-and-so, so-and-so. Farajuddin Ahmed is my father, Miller. But none of them were in possession in the plot of land since 1948 till date. Plaintiff number 1 and 2, along with the pro forma defendant 1 and 2 and 3 being wife, son and daughter of late Farajuddin Ahmed, have no right to claim ownership and possession of the land. My lord, they have not disputed the title of my father over the land, but they have said that you being the son, daughter and wife of Farajuddin, you do not have right. My lord, meaning thereby they have accepted since the president's predecessor's title over the land, they cannot deny our title because we were the son, my lord, legal heirs of Farajuddin. Now, so far, my lord, that question, third question is concerned the limitation. This is a suit of composite suit, my lord. Two prayers together. One is what we have pleaded in the plain for perpetual injunction because they started construction. The appellant started construction over the land from 5 to 2005. My lord, even it is in the plain also, page 16. Page 16 it is also, my lord, that from 7, lastly on 7 to 2005, when the defendants with the assistance of their workers and employees unauthorized started to dig inside the suit land for continuation of the illegal works of construction on the land. So therefore, without the permission of the landowner, you cannot construct over the land. So therefore, we prayed for perpetual injunction before the honorable court below, restraining them to going ahead with the construction. And since the cause of action for seeking perpetual injunction is of dated 7/5/2005, my lord, and the suit, my lord, having been filed in the year 2005 itself, my lord. So therefore, being this is a composite suit, my lord, for perpetual injunction as well as for compensation for unauthorizedly using the land. So therefore, the substantial my lord, prayer or issue raised will be the date for counting the limitation. Date for in a composite suit, my lord, date for counting of limitation will be come from the date when the substantial suit, filing the substantial right to sue accrue, my lord. So therefore, they have not raised this issue of limitation earlier. Kindly see, lordship, the issues from the appellate judgment, what it is written, what is the issue from page 68 by the learned trial court. They have failed to ask the issue of limitation.
It was raised, my lord.
Please.
WS it is raised.
Hey, তুমি এনেকে ক'লে হ'ব। মোৰ পিছত ক'বা। Page 68, my lord, these are the issue framed by the learned trial court. There, my lord, no issue frame on the law of limitation. My argument is that that's correct.
There, but is the court not obligated to the same?
Yes, lordship is correct, my lord. To that, I am adding to that, my lord. If one particular issue is not raised on earlier occasion, so what is the procedure? There is a procedure laid down, my lord, that they have to show in the appellate court before while in deciding the substantial question of law by your lordship that they had actually raised the issue. How lordship will come to know? They has to file an affidavit, preferably by the counsel appearing there, that yes, I raised this point. In spite of raising this point was not taken into account. From the issue framed by the trial court, it appears they have abandoned that issue, and even then they want to show they even raised this issue before the trial court, as well as the
No, that's not getting the merit now.
So even then, therefore, yes,
let there be two substantial questions at this point of time.
lordship may consider three only. Only one substantial question, if lordship so desire, I will address on that by placing the judgment at the time, my lord, hearing.
One is also there because some of the players are not there in the
My
time.
lord, even then that lordship has the power.
The-
That the second line lordship has, I have, yes, because, and it's for Zenial or other law, which may always given as the court may think fit and proper. That is there, my lord. The opening line, we have to read the
That is what, my
provision.
lord, that
We
is
have to
what-
read the provision as a whole. He is trying to read from the opening
No,
words.
I'm not saying that this
That
is
is not the
disjunctive. No, I'm
case.
not saying this is
So
disjunctive.
therefore, if lordship so desire, it's a one only three may.
No, one is most important.
No, for you it is important, but while deciding,
Mr. Das,
my lord,
is there any fear for handing over the vacant position?
no, this has come.
You tell me.
No, this is, I have not prayed for. I have prayed for perpetual injunction and for the,
no,
yes,
the has granted the delay.
yes.
Where is the boundary of the vacant position?
Of the land that has to be handed over.
My lord, in the suit land, this is there, my lord. Yes.
The entire
Page
suit land.
18,
The entire suit land.
page 18, in respect of two bighas of land, page 18, my lord, in the
That is in respect of the
Whole suit land.
whole suit land is,
which part of the whole land is like vacant.
Again, where is that?
my lord, 2 bighas is the entire suit land.
Huh.
And this boundary is 18, page 18.
That is there.
Yes.
What is the boundary of the vacant portion of the
My lord. My lord, because it is a open land. He is confusing before your lordship.
No.
This is not a permanent structure. They wanted to make it a permanent structure in 2005.
These are factual
Then-
matters.
No, no, no.
These are factual
No,
matters.
this has been determined by the, up to the appellate court.
okay?
Yes.
Or someone learn it for the decade does learn it. Subject for the
expired holy.
mark
নকৰিলে
declared it civil judge before ticket as first judgment dedicated that of 12 plus cycle 11 of 5 also declared that by just the learned for this the of 5 first here it is also the first judgment was trial court its second for that learned for third for the order the travel beyond the the husband that garden of their fantastic but they share that and for the part of each of the it's not return how or of the of art this of the record this is the method of art
My lord, so far that pro forma respondent 2 and 3 are concerned, on earlier occasion as the contented, my lord may record that, my lord. Pro forma respondent number 2 expired in 2009, my lord, and pro forma respondent number 3 expired in 2020. He can, my lord,
later on start that or respondent is offered device I get
2009, my lord,
And
Same
2020.
and the 3 is in 2020. My lord.
2020
Strike, may he may take steps for striking out.
for learning for the
It is already there, my lord.
Already there, na?
Five.
Bullein
Application
করেছিল।
five. Or application appellate. And degree dated the part if good like third of part affected evidence that needed of and like the non-opposite part that third one execute the uh, report. The title execute what is the
7 of 2021.
event of the then what is it the same
Pardon?
then what is it that
Nazir was asked
No,
to submit
read it,
report.
issued. Yes.
You were asked
For
to
report
submit
of
report.
Nazir.
read suit
Yes.
Yes, it was issued. It was fixed for a report of the Nazir.
state proceeding the current executive party read and matter is fixed on
It was fixed on 6th, my lord. Next date I am not aware, my lord. It was fixed on 6th of August.
fact that it's fixed for report. And that but the judgment that indicated paradigm that on it were and further fact that it for yet and develop the judgment of that number of that they till the I
Obliged, my lord. Deeply obliged.
The lordship, this is to go for hearing. The
Yes.
question of this, the policy was not a motor insurance policy.
other part
Yes, it's not on contempt.
of from upset that is five
Be pleased to I
yes
move
go
for
ahead, please.
respect number 2, 1, 2, and 3.
120 don't
Claimant,
please.
huh? Claimant.
That is the if the award challenge the count of violation of public no purpose or by reference of the and that's hearing taking care of
Hearing, okay.
Ahmed
Yeah, none.
authored
Look, I may be allowed 3 weeks time for filing affidavit.
filing
Affidavit.
no you are for authored
No, no, I am not for honor, my lord. I am the
for
claimant, my lord. Claimant.
in the meantime the file each objection or evidence
We keep that for you.
is subject
It's a pleasure.
Please, Your Lordship.
Yeah.
My Lord, there is delay in filing the appeal, my Lord.
87 days.
87 days, my Lord. They have filed the objection, my Lord.
Okay, David. My lord.
If I file objection,
Yes, my lord. I file objection, my lord. My lord, one thing is, my lord, at para, my lord, 5 to 6, my lord. 5, 6, 7, my lord. They have only narrated their official problems, my lord. Only officially it got delayed. But that is not a sufficient causes, my lord, to explain the delay, my lord. And on top of that, my lord, they had before coming to this honorable court, my lord, they had a discussion, my lord, privately, my lord, between the claimant and the insurance company, my lord, to settle the matter, my lord, outside court. And they had agreed with some kind of, 34 lakhs or something like that. In that case, my lord, my claimant, she did not accept it. Then they realized, then we had filed a Bakizai case. And after the notice of Bakizai case is received, my lord, by the company, then only they have approached, my lord. This is a, my lord, intentional delay, my lord, in coming to this court, my lord. On top of that, my lord, half of the amount has not been even, my lord, not a single penny has been paid, my lord.
That is, my Lord. My
Steady
delay may be condoned on the next date, my Lord, for admission. Then,
And the deceased was only 34 years old, my lord, with 2 children.
We are ready to release 50%, Lord.
All of them, my lord, parties, my lord, the mother, wife, and the 2 children, minor children. They are suffering, my lord, no source of income, my lord. The husband died at the age of 34, my lord. So that is the sufficient cause, my lord. I don't think, my lord, that is a sufficient cause, my lord. From table to table, the my lord, file goes, my lord. And it took, my lord, 2 months. Even advocate also, counsel also to my lord file the case, to prepare the case. So this is completely, my lord, a negligence in their part. Started from para 5 of their petition, my lord, condemnation petition. 5, 6, 7, 8, my lord. These are the paras they have given the causes, my lord.
that of the appeal, then the 50% amount
Yes, yes, my Lord. That is my undertaking, my Lord.
If your lordship considers this, my lord, if at all it is accepted, my lord, the delay is condoned, my lord, then 50% may be, my lord, deposited by them. That may be a direction and released to them. They are going through severe hardship, my lord.
We are ready, my Lord. We are ready to deposit.
Severe hardship, my lord.
that's all right. I think the conduct delay
My lord, as your lordship thinks proper.
and that Pakistan proceeding will go on.
Yes,
unless
that will
we
go on.
stay-
Yeah, my lord.
stay there.
My lord.
But for staying, they have to deposit the 50% of the
Yes.
My Lord.
Yes, my lord.
My Lord.
And that may be released, my lord, to the claimant.
So, they will only conduct the delay.
Right.
Thereafter, the appeal will be registered by the registry, and it then consider that they are staying the not today.
Next week.
Appeal. Whether your good name, please.
My lord,
Your name, please.
MD Chaudhary, my lord. My name, my MD Chaudhary.
This application. 5.
Yes.
They will take whatever dated like, eight, the Kobita card, after the after pronouncement the judgment can refer on by the can get in the public certificate of where you have provided the
My lord, the dealing advocate had furnished the copy to the branch office at Mongoldoy, my lord. And then the entire file had to be transmitted to regional office at Guwahati.
appellant and thereafter
It was transmitted to Guwahati regional office, my lord.
thereafter the and thereafter
My lord, the dealing advocate was supposed to give an opinion, my lord. That opinion was not given. Then, lordship, the present counsel was approached. Then I gave the opinion, lordship. That is reflected in para 6, my lord.
thereafter was forwarded the dealing advocate. But part and thereafter the team and after by decided to by the appeal dot dot and uh and explain in or
5 to 8, my lord. 5 to 8.
6, 8
8.
and then argue for part of Friday the it the other that opposed the account that is 7 per not subject where after the but the six or eight here to yes as it was and after the for the delay of 7 per the MS then it starts of the order of I now that is for as so
Lordship, since the execution proceeding is pending, my lord, may I prefer
you
fixing a date,
you
my
go
lord?
to the registry and ask them to fix the
My lord, my lord.
My lord, can it be a date, my lord, because it
No.
is urgent, my lord. Since the delay is condoned, my lord, let me be admitted, my lord. Appeal is admitted.
No,
We'll
appeal is
approach
not
straight.
put there. It's that
But-
appeal is yet to be registered. Since delay is
And-
not there, now the registry will register the appeal.
My lord, the copy has not been given.
I'll serve.
That may be, my lord.
I'll serve.
Copy.
Memo of appeal
I'll serve. Fetch. The regular first appeal arising out of the judgment dated 29/5/2025. My lord, let the appeal be admitted. Notice will go, my lord.
the third This appeal under reading to order 41 of the directed against the government dated 2025 entitled to number 4. It was prepared by Chief Judge of Head. It's the part by the appellate. Declaration recovery of cost of the there is a memo within the government that ethics notice that begin by Mr. Alien is subject for the report.
Well, the regular second appeal, first appeal.
You by the seven learn the the number one degree the response. First, the memo of evidence and the document of first the seven by admit is not later. There is only one respondent.
One.
It's a matter after forensic. I for
For stay of the evening,
whether execution proceedings started.
not.
That notice to yet.
Okay.
Basically, this Malad may take up item 15 first.
Both are related.
Both are related, coming out of the same judgment and decree.
Then why two evidence?
One against the dismissal of allowing of the counterclaim and dismissal of Masood.
Yes.
The case here is very similar. Proposed substantial question of law is at page number 5. The counterclaim has been filed by a person, my lord, entity, wherein, my lord, who was never gifted the property, my lord. I have annexed the gift deed also, my lord. The court below has not looked into that aspect of the matter. At page number 5, my lord, 1, 2, and 3.
is there a finding the evidence that the person not acting?
No finding. In fact, all the essential ingredients under section 147 of the Mohammedan law relating to gift, hiba, that was not even discussed by both the courts below. My lord, may just come to page number 47 for once. Who had filed a counterclaim? Counterclaim was filed by one Musammat Reena, alias Reenu Begum. She is the president of Tinsukia Gaon Panchayat. No document has been furnished, my lord, annexed with the written statement as well as with the evidence, my lord, that she is the president. Now, my lord, I'll take my lord to the gift deed. Who was given the gift? Although we are saying that, my lord, there was no gift deed executed, just for argument's sake, my lord, if we admit that the gift was executed by our father, then, my lord may kindly come to page number 116A. Annexures 8. Counterclaim was filed by my lord, the president, so-called president of Tinsukia Gaon Panchayat. Now, my lord has got the gift deed, my lord. This deed of gift is executed by A. Rahman, Abdul Sattar, Izahar Ali, Asaruddin, son of Basir Ali Sarkar by religion Muslim by profession so-and-so, sub-register office at Rupohi in the district of Nagaon, in favor of President Gaon Sabha of village Tinsukia. So, gift was given to Gaon Sabha, Moja Juria Police Station, Rupohi, district Nagaon, and to the President Tinsukia Notun Bazar Committee. But these persons or the legal entity, they have not filed a counterclaim. Counterclaim was filed by a stranger third party to the gift deed. And moreover, my lord, whereas there is no Notun Bazar in our village, and since people are facing difficulties, Notun Bazar of village was running somehow. There are difficulties running the bazaar because of shortage of land. There is land belonging to us near the bazaar, and we are facing difficulties in cultivating over the same. The bazaar committee and the Gaon Panchayat approached us to give the land for conveniently and smoothly running the bazaar to the president of the bazaar committee and Panchayat committee, and accordingly we gifted the land measuring 2 bigha of that mentioned in the schedule in favor of the said two committees. So there was no declaration, although we may say, my lord, since the gift was executed, so there was a declaration, but there was no pleading as to regard, my lord, that the gift was accepted and possession was delivered to the donee, my lord. Neither the trial court has held to that effect, neither the appellate court has also given any finding with that regard. And what was the locus of the counterclaimant, that is also not been discussed, my lord. How she could have filed a counterclaim without the gift being gifted to her.
Trial court
Decreed the suit. Against that, we have filed an appeal. My appellate court has also dismissed my appeal and allowed the counterclaim. Dismiss my suit, my lord, and allowed the counterclaim. First appellate court has again dismissed my suit and allowed the counterclaim. And admittedly, my lord, the plaintiff and defendant, they have admitted that it is the property of Isahak Ali, who is the father of the plaintiff. And the defendant number 2, 4, and 7, they have also admitted that they are tenants under me, and they have been running their shops, tenanted premises from the suit land for a very long period of time, and they are not the tenants of Gaon Panchayat. So there was no delivery of possession as such. And in fact, in all the cross-examination part, if my lord goes through, when the record comes, my lord, then it is admitted by all the defendant's witnesses that the Notun Bazar that was to be constituted, that is far away from the, at least half kilometer, 1 kilometer away from the disputed land. So that also proves that, my lord, no possession was given to them. And in fact, they have admitted that I am residing, that the plaintiffs are residing with their family members in the disputed land. That has been corroborated by all the defendant's witnesses. So situated thus, my lord, since there is no delivery of possession and the counterclaim has been filed by a stranger, my lord. The counterclaim ought not to have been admitted.
But because appellant the thereby appellant by the verdict of the defendant was the person getting on the get of the that was whether the defendant was or suffered or on account of the item taken under it
49.
149 the Mohammedan
Mohammedan.
yes that partake the information must get out or that is because of that under the but
Well, at the time of hearing, if anything,
yes
well, a notice may be issued only upon respondent number 1. Others may be struck off because they had not filed a counterclaim. I'm praying for striking of the name of the other.
better than before the petition getting rid of or the concern for the appellant of the name of other response being the number
2 to 10.
yes, then track the area of as they have
As they had not filed a counterclaim. Counterclaim.
fight the counter the name of the
10.
track of the appellant list of
In item number 14, similar order, my lord, I'll take steps upon all the respondents. Same, my lord.
My lord, Mr. DK Das, engaged counsel is out of station, so I may be allowed to move this case.
Pardon?
Mr. DK Das, he is the engaged counsel. My lord, with some personal difficulty, he went to his native place. So I may be allowed to, my lord, move this case. My lord, this regular second appeal is, my lord, filed against the concurrent finding, my lord. Lordship, already we have filed the, my lord, amended appeal memo, my lord. So, Lordship, this suit, my lord, page 51, my lord, is the, my lord, judgment and decree passed in the title suit, my lord. So, my lord, this suit was filed by the, my lord, respondent, plaintiff, and we are the, my lord, defendant in the suit. So, my lord, suit was filed for ejectment of the appellant defendant, and that suit was, my lord, decreed in favor of the plaintiff, and that was subsequently affirmed by the, my lord, first the trial appellate court, and against that order, my lord, we have filed a second appeal. So, Lordship may kindly come to, my lord, page 54. My lord, may I read, my lord?
Yes.
Page 54, my lord. The brief fact of the plaintiff case as unfolded from the plaint is that plaintiffs are the joint owner of the homestead land measuring 1 bigha situated at Paltanpatti, ward number so-and-so, Gulaghat town, covered by eastern portion of Dak number 1910 under PP number so-and-so of Gulaghat town under Mohua Mauza, more fully described in the schedule of the plan. The plaintiffs acquired the right title to the suit land by right of inheritance from one Sher Khan, who was the owner, patadar of the said land and who died on 29/8/79. Sher Khan was the maternal uncle of the defendant number 1 and 2. My lord, defendant number 1 and 2 is my father and my uncle. That is the appellants, my lord. The mother of these two defendants was Muhammad Saru, who predeceased her father Sahabuddin, the original owner of the suit property, died in 1973. The original defendant number 1 and 2, while they were minor, were living under the care of their maternal grandmother Muhammad Dahi, who was residing at a house situated on the suit land, and the said house stood in her name in the municipal record till 1956 to 57. When the said house became dilapidated, the defendant number 1 and 2, with the permission of Sher Khan, constructed a new residential house in its place. Sher Khan allowed these two defendants to remain in occupation of the suit land as a joint tenant at the rent of rupees 20 per annum for several years, that is rupees 10 from each of these two defendants. When Sher Khan demanded an increased rental of rupees 30 per year from the defendant number 1 and 2, they showed their unwillingness to pay the enhanced amount of rent to Sher Khan. On 3/12/81, the plaintiff sent a notice to their lawyers, the defendant number 1 and 2, determining the joint tenancy of the defendant on the ground of forfeiture, and asked them to quit the suit land and surrender possession thereof to the plaintiff within 30 days of service of the notice. But the said defendant refused to accept the notice when tendered by the postman, and they were still possessing the suit land. After the institution of the suit, the defendant number 1 constructed a house with wooden post and CIC roof and allow his eldest son, the defendant number 3, to occupy the same, and accordingly the defendant number 3 has been occupying the same. In the month of June 1984, the defendant number 1 started some pakka construction work in his two house without paying heed to the notice dated so-and-so, whereby he was asked to desist from going on with such construction work. Hence, the plaintiff has instituted this suit for khas possession of the suit land by ejecting the defendant therefrom
along with cost and any other suitable relief to which he entitled. My lord, before filing this suit, so many ground of my lord litigation has been, my lord, filed between the suit has been filed between these two parties, and ultimately by this honorable court, it is, my lord, confirmed that defendants are not entitled for right title interest; they are permissive occupier. Subsequent that judgment, my lord, this respondent plaintiff filed this suit for ejectment and recovery of possession. Then, my lord, kindly see para 3. Summon was issued to the original defendant number 1 and 2, and they appeared before the court and contested this suit by filing their common written statement. The defendant number 3, on being made a party to the suit, filed a separate written statement. After amendment of the plan, the defendant number 1 and 2 filed amended written statement. They contested the suit on the ground that there is no cause of action for the suit, that the suit is barred by law of limitation, principle of estoppels and acquiescence, res judicata, and the suit is bad for non-joiner parties, and that the suit is non-maintainable in the present form. In the written statement, it is asserted by the original defendant number 1 and 2 that possession of the suit land was delivered to them by late Sahabuddin, the maternal grandfather of the defendant, as a gift under the Mohammedan law, and the defendant used to stay on that land by constructing their own house and paying land revenue. It is also stated in the written statement that the original defendant number 1 and 2 jointly constructed the house in 1937, and they got the house assessed by the Golaghat municipality in the name of the original defendant number 1. On the date of Sahabuddin in 1937, the defendant number 1 and 2 became the absolute owners and have been enjoying the land till today as stated in the written statement. The defendant number 1 and 2 further stated that they are not tenant under the plaintiff or under the plaintiff's predecessor in interest at any point of time, since the day of occupation of the suit land under any lease or verbal agreement, and as the original defendant do not forfeit any right in using and occupying the suit property, and hence they are not liable to be ejected. It is also stated in the written statement that the plaintiff's predecessor in interest waived their right under the principle of acquiescence by allowing the defendant to possess or occupy the suit land for a period exceeding more than 30 years, and hence the present plaintiffs are stopped from instituting the present suit under the same title. The defendant denied that the plaintiff have inherited any absolute right title to the suit property. It is also contended that the suit cannot proceed for want of proper notice under Section 100 TP Act, and the suit is barred by Order 2, Rule 3 of the Code of Civil Procedure. The original defendant number 1 and 2, in their additional written statement, stated in the case the plaintiff are held to be landlord of the suit land and defendants are their tenant. The defendant cannot be evicted from the suit land as they have constructed a permanent structure on the suit land immediately after they took over possession of the same. Apart from that, the original defendant number 1 and 2 have on the suit land dwelling house, kitchen, latrine, etc., having valuable trees grown by them on the suit land, the value of which is not less than 70,000. They also stated that if the defendant are evicted, they are entitled to compensation of the 70,000 from the plaintiff. The defendant number 3, in his separate statement, stated that he has been wrongly implicated in the suit. He denies the content of the paragraph number 14 of the amended plan. He also stated he is not liable to be evicted from the suit house under Assam Non-Agricultural Urban Area Tenancy Act 1955. Hence, the defendant had prayed for dismissal of the suit with cost. During the pendency of the suit, the original defendant number 1 and 2 had expired, and their legal representatives were substituted in the place of them. The suit proceeded ex parte against defendant number 3 by order dated so and so. During the pendency of the suit, the plaintiff number 10 also expired, and her legal representatives were substituted in her place by order dated so and so. The defendant number so and so submitted their common written statement. On the basis of the rival pleadings of the parties, my learned predecessor in office framed the following issues. My lord, these are the issues, and my lord, then following additional issues also from my lord framed in page number 58. Then my lord, para 7. After going through the evidence on record, both oral and documentary, my learned predecessor in office decided all the issue in favor of the plaintiff and passed the judgment on 18/7/1985. And passed the decree in favor of the plaintiffs for ejectment of defendant from the suit land. The defendant preferred an appeal being title appeal number 4285 before the learned Assistant District Judge Jorhat against the said judgment and decree. the appeal was partly allowed. My lord, this was my lord, this appeal was the first appeal, my lord, first round of appeal. So in that appeal, my lord, the appeal was partly allowed. And my lord, appellate court decided that the decision arrive in respect of this issue frame in the suit stand as they are, but frame an additional issue, whether defendants are entitled to any compensation on their eviction. If so, what extent? And remanded the suit to this court for fresh disposal with the direction to decide only this additional issue and dispose of the suit. Thereafter, my learned predecessor in office decided the said additional issue in the negative and in favor of the plaintiff by order dated so and so. Against the order dated 2/6/1987, the defendant preferred an appeal, and this is second round of appeal, my lord, being titled appeal number 4387. Before the Court of Learned Assistant District Judge Golaghat, and while disposing of that appeal on 9/12/87, the suit was remanded to this court again with the following observation and direction. Since there is no judgment and decree in force, this court, being first appellate court, cannot pass an effective order incorporating the decision of the additional issue. Therefore, I find no other alternative but to remand this appeal with the direction that learned Munsif shall dispose of the original suit afresh only after taking into consideration the decision arrived at by him in the additional issue. So, my lord, this was the observation by the, my lord, second round of, my lord, title appeal, my lord, filed by the present appellant. Then, my lord, after that order from the, my lord, appellate court, this, my lord, the learned Munsif, my lord, passed this order, impugn order. And that's impugn order only decided only on one issue, my lord. Kindly see, this is this discussion and decision and reason thereof. Additional issue, my lord. The additional issue framed by the learned appellate court is whether defendants are entitled to any compensation on their eviction, if so, what extent. My lord, this additional issue, my lord, this additional issue was framed by the, my lord, the first round of title appeal filed by the, my lord, present appellant, and that is title appeal, my lord, 4285. My lord, that was again challenged, my lord, by 4387. My lord, 4387 say that the Munsif is, my lord, learned Munsif is to, my lord, consider the suit afresh, taking into consideration this additional issue, my lord. But here, my lord, the learned Munsif, my lord, what he done, my lord, only the additional issue has been decided, not the whole issue, my lord. Suit. Lordship may kindly see. Additional issue. The additional issue framed by learned appellate court is whether defendants are entitled to any compensation on their eviction, if so, to what extent. After the suit has been remanded back by the learned assistant district judge, Guwahati, the defendant have adduced the evidence.
Earlier, by the trial court was not disturbed by the first appeal.
My lord?
Not interfered with by the first appellate.
No, but in the first round of, my lord, title appeal, partly interfered. In PA number, my lord, this and this, well, suit is considered third time. In the first round of, my lord, title suit, that was dismissed, and, my lord, that was allowed in favor of the plaintiff. That was challenged, and by filing title appeal number, my lord, 4285. In that 4285, my lord, learned assistant district judge, my lord, partly allowed the appeal filed by us by framing an additional issue, my lord. And the additional issue was whether the defendants are entitled to any compensation on their eviction, if so, to what extent. So again remanded back to the, my lord, learned trial court for deciding this issue. And against, my lord, learned trial court, by deciding this issue, my lord, additional issue, dismissed this, my lord, not allowed this additional issue. Again, we have filed another appeal, my lord, against that order. That is, my lord, title appeal number 4387. 4387 said, again remanded back, saying that this suit may be considered afresh, taking into consideration the additional issue. Not only the additional issue, my lord. But what the learned Munsif did, my lord, only the additional issue has been decided and decreed the suit, my lord, in favor of the.
The first appellate court judgment.
My lord, that is not annexed here, but that is already reflected here.
But
my lord, that is. My lord, a first appellate court.
Yes, first appellate.
Yes, 4285.
Yes.
Which was partly allowed.
And also the second decision of the appellate court.
Yes, second decision, my lord, this is 42-87. The first round of the title appeal was, my lord, 42-85. That was remanded back with partly allowed by issuing by framing an additional issue. That was against not considered by the trial court. Decreed the
That decision,
yeah, my lord. My lord, I have the copy of this second round of the title appeal, my lord. 87.
first round.
First round is not, I think.
That is the draft copy. That is the draft.
Yes, my lord. My lord, that copy is not there. My lord, only I have, my lord, I have the copy
No,
of.
I have no. All issue has been decided.
My lord, this is suit of 82, my lord. Now I have the copy. My lord, this second round of title appeal, I have the copy, my lord.
What is the first decision?
My lord,
Third, it's already
No, my lord. My lord, 347, 8, 9,
8 and
10, 3 to 10, 10, 9.
10.
In early order, it is reflected, my lord. That's early order.
Okay. 3, 4, 8, 9, 10, 10, 9. But the sub for the of the appellate court in appeal number
4285.
40 to 85 or next step by filing an additional appeal.
My lord, my only concern is, my lord, already title execution has been already proceeded.
Where
My lord, already I have filed an additional, my lord, affidavit along with the IA, my lord.
Next date on my lord, 20.
No, 10, 10.
10 is Sunday. Next date is 20. 20.
20.
10 is the Sunday.
exit
My lord, 10. 40. My lord. Please,
make the lordship. May kindly read the order dated 28/7, lordship. Lordship has directed the registry to verify the notices served upon the respondent, how they were served, lordship. The office notice dated 22/8/2023 now. As per office report, lordship, notices were issued. Whether they received or not, lordship, that is not clear from the office report. Only notices has been received.
Or four.
Six paragraph, lordship. Notices have been received upon respondent number 4 and 5. 4 and 5 only received. Others office note or lordship notices has been issued. No, this last office note 31/7/2025, lordship. As directed by the Honorable Court, notices has been served upon the parties through both Talabana and Postal Talabana. The service report by usual process for respondent number 3, 4, and 6 has been furnished by Civil Judge Junior Division of Jorhat has been received in the section and same has been tagged. So 3, 4, 6 complete, lordship. Respondent number 4 received copies in person and notice for respondent number 3 has been received by the assistant of the concerned organization, while copy for respondent number 6 has been received by the husband of the respondent. No copy of postal Tanabana has been returned to the section unserved, as such the matter is placed before the Honorable Court for necessary order. Only in respect to 3, 4, 6.
And as per earlier office note 22-8, Lordship,
appellant proceeding for number 4.
Four.
First office note, Lordship, 16-7 says service complete as such matter is laid before the honorable court.
For the stated third, then it will one
Three,
then in aspect of 5
Complete.
Lordship, as per office note 22-8-45 complete. Notices has been received upon respondent number 45. And as per office note 31-7,
the matter is ready for
3, 4, 5, 6. What about 1, 2?
accordingly it is provided that the matter for hearing in the court.
Lordship, no report in regard to 1-2, Lordship. Respondent number 1-2. Only notice issued, whether they received or not, Lordship.
And the prayer also jointly arises for 1 to 4.
Yes, Lordship. My claim is against 1-4, Lordship. So registry may be directed to track the tracking report, Lordship.
Well, these are the insurance companies. They must have standing counsel for. These are the insurance companies, the first and second respondent.
New
must be
India
have-
Assurance Company is
Who
available.
is the respondent number 1?
One is New India Assurance
Insurance
Company Limited, Mumbai.
It
Address.
is served notice upon the counsel.
No, Lordship, it is mandatory to serve copy through registered or usual, and thereafter they appoint their SC. Lordship. Divisional Manager, New India Assurance Company Limited, Dibrugarh, and Branch
With
Manager,
phase
Assurance. If your Lordship directs someone from the
It appears that the number 1
Oh, present. No.
is yet to be completed and the most dated
New India,
37
India,
and
New India.
are cited
Oh.
that the up to date of this after 1 week.
Apply.
Oh, yes, sir.
May it please your lordship. My lord, this contempt petition is for non-compliance of an order whereby this honorable court had directed to release the Arakanats on furnishing an indemnity bond. The order is at page number. My lord will find the order at page number 36.
Sir, not for the
Malad, I have got the information. Malad, the petitioner, respondent number 1, he retired about 6 months back. So as of today, he has no instruction. But at that point of time, Malad, he had informed that there is another criminal petition where a stay order is there in respect of the judgment passed by the learned additional session.
It is there in the affidavit filed by the respondent number 2. That is there on record.
Affidavit in opposition has been filed by the respondent number 2.
Yes.
They have also brought it to the record of the honorable court, Lord. Against this judgment only, if lordship kindly comes to page number 36. Page number 36 of the contempt petition, the order which has been alleged to have been violated.
It's number 30.
36 it starts, relevant is 37. Lord. Second paragraph. By this petition under section 482 CRPC, the petitioner have prayed for partial modification of the impugned judgment and order dated 38/2022 passed by the learned additional session judge Kamrup Amingaon in criminal revision petition number 42 of 2022 by removing the condition of bank guarantee as well as allowed the jimma of the seized article to them on the basis of execution of indemnity bond. So against this particular judgment, already the order I have handed over, that is against this same judgment dated 38/2022, one criminal revision petition was filed by the state, and
That is pending for
that is pending for decision. So there is a stay order, and at the same time, this order is there that on has been modified that by providing indemnity bond, you release them. release the item. No, it would be appropriate if Lordship kindly directs to list this contempt petition along with the criminal petition.
Along with?
Along with the criminal petition pending.
My lord, what might have happened, because I have been newly engaged in this case, what I feel, what might have happened in this case, because this criminal petition is filed by the state. Just now I have seen, few minutes back, I have got a copy from this. My lord, this criminal petition, while they have filed this criminal petition, they got a stay order, and in all likelihood, probably the office of the public prosecutor has not taken steps. Now, if they don't take steps, the petitioner of this contempt petition will not come to know about this order. But I'll also take instruction regarding this, because apparently there is a stay, the same judgment I have seen, and the modification order is also with regard to the same order. Apparently, these are the two orders. But what has went wrong, I don't know. I'll also take instruction, but be that as it may, my lord, at least the private the respondent number 1 in the present contempt petition, though he has retired, but he should also, in my understanding, my lord, subject to what your lordship says, file an affidavit to show as to what steps he had taken while he was in service to comply with this order. Because the respondent number 1 has filed an affidavit, he has also retired. Respondent number 2, he has also retired, but he filed an affidavit where he said, these steps I have taken for compliance of this order, but now I am retired, I have delegated it to my junior. He has given his affidavit. He should also, my lord, file an affidavit that what order. And my lord, both the orders are passed in the presence of PP. Here the PP was petitioner in this case where they stay, and here the PP was respondent. So both are filed in the presence. They could have, when this order was passed, this modifying bank guarantee into indemnity bond, the learned PP should have brought it to the notice of the court that they didn't stay operating. I mean, how it happened, my lord, I am also shocked, my lord, because, but yes, I'll also take instruction from my client.
Contempt doesn't lie. That is number 1. And second is, my lord, the respondent number 1, he has informed me that because of this stay, he could not take any step. That is his instruction. And he retired in 6 months back. At this, my lord, my humble submission is, my lord, along with since the petition is pending, this may be checked with that. Ultimately, things will be clear. Otherwise, this petition is not maintainable as on today.
My lord, petition is maintainable. How far this order, because my lord, contempt is when there is a willful disobedience of an order of the High Court, petition is maintainable. So whatever I understand, I could not lay my hands on any judgments, my lord, which say that it is not maintainable. This is one. Second,
No. It's a given
absolutely
background that one stay order is operating. How can
absolutely, my lord. I'm just because this is apparently there is a contradiction. There is something, my lord, that I'll also take that.
Anyway,
And this record has to be tagged with. Yes, whether steps they have taken or not, that is something has to be seen. Because just
M. Bhagavat. Respond number 2.
What?
2. File that.
Order of a coordinate bench of court dated 28/4/2023 whereby the order dated 30/8/2020 hospital allowing the director allowing FIMA of the not subset matter like with the criminal case number 8 for which that after a week.
In the meantime, they may file an affidavit, my lord. at least their version should also come on record, my lord, because
They
have filed, he has filed,
This order is on record, Lord.
He has filed. I'm not saying about him. He has filed, I'm saying, but at
But
least Mr. Nath's client may file an
this
affidavit.
is a contempt matter, Manoj. Lordship, I am appearing on, as an advocate for the respondent number 1. And after 6 months of his retirement, it is very difficult to find. Otherwise, the order, in any case, if the order is to be complied with, the present incumbent has to be compliant. In fact, Lordship will see on
the other
Lordship.
like,
Lordship.
Okay.
no notice has been prepared.
Yes.
Or sir,
R. Bhuya, Lordship, on behalf of Mr. S.D. Roy. R. Bhuya, on behalf of Mr. S.D. Roy.
Learned Counsel, Eviction of Officer, SDR, dated 6 you want to take ICSF or will await
Lordship, service report. If
there is a matter after 2 weeks.
Lordship may kindly fix a date if possible.
No.
Please appreciate the conditions under which I has been filed. Lordship.
Lordship, may I kindly take up this matter next week.
Next week.
Next.
What is the matter?
My lord, the IO is for condonation of delay. Here, my lord, delay is
640 days.
640 days long.
Okay.
613 days.
Made by not but on fix it then
Mal.
Perhaps, my lord, the date is fixed for execution, my lord, on
19th this is paid. It is paid. In the law court, on 19th case is paid.
before that.
okay. Then 16. Okay.
14?
14.
18.
18. But the interim order is till today. Till next. Lot. Over.
In this case, the respondent filed an objection
Yesterday, my lord, I have filed wakalatnama for respondent number 1, along with the objections on behalf of all the respondents, my lord. Perhaps it is not on record. Let it come on record, my lord. Matter may be taken up any day, my lord, next week.
Monday, Lordship, or Monday, Lordship.
I'm waiting for response.
Wednesday.
That's not for the
1 to 4. 1 to 4. 1, 2, 3, and 4.
For 5 and 6. 5. So does that 5 but the not best.
Highly obliged.
The objection may be tagged with the record. Obliged.
IA 989 is for condonation of delay. Regarding service, my lord, there is no specific whether that has been completed or not.
You are appearing for?
Lordship, the respondent number 16.3, there are several respondents, Lordship. 4.1, 4.8, 2, 3, 2, 4, 2, 5, 2, 6, 5, 3, 5, 4, 6, 2. There are several respondents, Lordship. And Lordship, as per instruction from the respondent's Lordship, the respondent number only for 2-2, they filed the substitution petition, but already other respondents also died. 2-1, 3, 5.2, 6.1, and 9, Lordship. Several respondents died, Lordship.
HK Sharma.
SK Sarkar, Lordship. One, 6, I will write it. 2-1. Lordship, respondent number 2-1, that is Chanchal Burman. 1. Chanchal Burman. Respondent number 3, Rasamati Burman. 3. 5.2, 5.2, Parmananda Burman. Purnendu, Lordship, sorry. Purnendu Burman. 6.1, Chinmoy Burman. And 9, Sonakabala Burman. 9, Sonakabala Burman. If possible, Lordship. Lordship. Obliged, Lordship.
Yes, Your Lordship. There is a delay of stated to be 28 days, but Lordship, it's actually 23 days, Lordship. What has happened, Lordship? I had done it correctly, 23 days. We changed it. But I'll show you, Lordship, this judgment is stated to be dated 9/9. But it was in the first page, Lordship, 9/9. But in the last page, it's written signed, sealed, and delivered in the open court on the 12th day of September. But that's why I told the registry has made it. So instead of 23 days, it has been.
Any objection?
Lordship, I don't have any objection, but that may not be recorded. I have also filed one objection in the delay petition, Lordship. But delay may be condoned and main appeal may be listed for. Only Lordship. May I submit one thing, Lordship? The response number 2 herein has already died, Lord.
They are pro forma respondent.
Response number 2 has all.
You are for respondent number
3, Lordship.
number 3.
3-1. P2.
Sir, Krishna has pointed out that respondent number
2
suffered demise.
Yes, Lordship. Paragraph 29 of the judgment, Lord. before
number 2 is already covered in
during pendency of the trial
penalty of the
trial process.
MSC case
Yes, Lord.
or appeal.
MSC case, Lord. Case 21, Lordship, paragraph 29 of the judgment. During cross, Lordship, the respondent number 3 have categorically stated that now her husband is no more.
Yes, Mr.
That can be struck off, Lordship, because I didn't notice. I went by the cause title.
Instead, the name of respondent number 2 is struck off the appeal. Accordingly, the name of respondent number struck off at the close of the line. Respondent number one. Any objection in concerning the delay? This interlocutory application under section 5 of the Act, they do it provision section 1 is covered by the applicant for 8 days and referring have connected with the word is for but number 6 of M M or double 8 by applicant said to the pronounced for yes the applicant not violate right on account of
Lordship, in para number 2, Lordship, award was obtained by the dealing advocate on 26/9 and the company got in 14/10.
on account of delayed signing of the certificate copy of the judgment and approval.
Yes, Lordship.
And therefore approval that the delay is not intentional. Allow so this number
3.
Number 3 and start Kalim for number
1.
or 1. You have objection? No objection. And they have objection in the over it's that having heard the parties of the and so statement that are paragraph number 2 explain that was and I find that it as something in the order but now that it's from the appeal
Lordship, so memo appeal may be served upon the
I'll give it tomorrow. No, Monday.
and our name may be shown while appeal is got listed. Lordship. Otherwise, my name might not be published.
Here in this matter, Your Lordship, we have filed objection, Your Lordship. Probably that is not on record, Your Lordship. It was filed on 6th, Lordship, 6th date. Lordship?
Next week?
Yeah, Lordship.
Can it be Tuesday, Your Lordship? You respect it. Because the appeal is for execution, Your Lordship, the main cases, Lordship.
Wednesday, third for a learning.
He go going.
Why?
May it please your lordship, my lord. This is a revision petition, my lord. What happened? Lastly, learned counsel for the sole respondent has appeared, my lord. This order is at page 21. My lord, this is very simple, my lord. The ex parte order vacating petition was filed, that was rejected by the learned civil judge junior division number 1 Nagaon, my lord, at page 21. My lord, this suit is pending, and the defendant number 1, this petitioner, is a resident of Dakargaon, Tezpur, my lord. But in the plaint, her address was wrongly given. The address of the plaintiff and the defendant number 1 and 2 was given the same address, my lord.
You are for respondent number?
No, sole respondent. Yes.
So matter is ready for hearing.
My lord, no. What they say.
Your Lordship, I have no objection if the petition is a law. But my only submission is that, my lord, the respondent.
No, you see, today the matter is listed under the column stay matter.
Yes.
We only consider the stay today.
Stay, my lord, stay is granted. Stay was there, my lord.
Till when?
Stay is continuing.
Until further order. So, my lord, today, if your lordship dispose of also, because they have no, but the defendant will file their WS, my lord, in the meantime. Next date, on the next date, my lord. Because they say, my lord, they have no objection.
My only.
Suit is pending in between, my lord, they are brother and sister. Let this defendant number 1 be appear before the trial court and file their WS, my lord.
My only submission is that, my lord, the petitioner may be directed to submit the written statement within 1 month, because the matter is very pending.
Okay, my
since
lord.
2021.
Okay, my lord.
Third, Mr. Goswami, learned for the third.
I am Pandit.
M.
Pandit.
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 Third, one matter. It's petition under Article 27 of the
Read it section 151 of the section.
the but whereby the submit this petition under section under order 9(7).
Yes,
The civil revision petition.
yes. It was rejected.
No, no. Petition is not maintained. Appeal lies against the order. Under order 9(7).
That order, this order, against this order, my lord.
Yes.
Since my lord suit is still pending against the defendant number 2.
Maybe. If the petition itself is not maintainable, why should we done that? This is an appealable order. Let us fix it on the next week. You come prepared on this point. Whether appeal will lie or petition will lie. Because at the same way we have one petition. Then say if we allow this petition, then it will send a verdict.
But my lord, what happened if they agrees, my lord? If they agrees,
No. They may agree. But we cannot pass such order. But there is a matter of I think to hear on the point of maintainability.
obliged.
That material matter is regarding only permanent alimony.
Any instruction?
Actually, I have discussed with the respondent, and he has to like one-time fixed permanent alimony as 50 lakhs.
Better now. Otherwise, or may I put one
Then
one date?
Whether the affidavit disclosing the assets and liabilities are placed on record.
Who myself?
Yes, both the parties.
That is not because otherwise Hindu Marriage Act section 25 she is supposed to file application before the trial court for decision for court below for application is to be made. That is the procedure. He has to make he has or he has to make application.
Filed before the trial court order. Filed before the trial court order.
It was actually filed before the trial court in 2018.
It is part of the record.
Section 125, one petition was
That is
filed.
maintenance.
That was for the maintenance,
Maintenance.
not under section 24 or 25. It was
25.
under 125.
Maybe, but the text would be same.
Yes.
But
in fact, but I mean, not admit. I'll take further confirmation, seek for all the detailed records, and I'll place it before.
Okay. Then file a file on
Yes.
or
or appellant. Appellant. This is the place of matter. 9th of September. 9th September.
In the meantime, it is provided that both the parties have filed their affidavits and liabilities in view of the decision of Honorable Supreme Court in the case of Brazil versus Neha. What is the citation?
Lordship, 2021, volume 2, page 324.
2021. SCC?
SCC, Lordship. 2021, 2 SCC, 324.
Page number
320.
We are putting best effort, my lord. We are putting best effort. This material matter, they are having problem, but when it come to us, my lord, it is for lordship also, for us also. These burdens come to us.
It's long with for 34.
Hello.
Yes, sir.
Hello, Vlad.
With regard to item number 26, if your lordship grants me liberty to file appropriate petition before the trial court or the appellate court, my lord, I may be allowed to withdraw this.
Okay.
Because this liberty will at least give me some, my lord, benefit to, my lord, file this appeal. If, because no decree was passed.
Mr. Contempt, counsel for the that court then approach the learned trial court.
Trial court, appellate court, lower appellate court, trial.
Learned trial court. By filing appropriate petition, by taking to the submission of learned counsel, the part of what part approach the trial gate file appropriate and okay appropriate.
Oblige, my lord, oblige.